Hello, everybody. Best regards to Munich. My name is Walter Schober. I'm the presiding judge of the UPC in the local division in Austria, in Vienna. Thank you very much for the opportunity to speak to you at this forum. Unfortunately, it is not possible for me to join you. I'm on the way to Hamburg, where we are having an UPC trial in the next 2 days. I called my short presentation UPC an active process. Now we can look back 1 year of UPC case law. Therefore, I give you an overview about the caseload and the allocation of the languages of proceedings. Then I want to talk about the work in the panel between the technically qualified judges and the legally qualified judges. And then I will talk about one of the last cases which I had in Munich. The caseload in the first instance is really high. We have 373 cases. Most of them are infringement actions, followed by revocation actions and provisional measures. Although we have counterclaims for revocations. The breakdown is the most of them are in Germany, especially in Munich, followed by Düsseldorf and Mannheim and Hamburg. Therefore, the Court of Appeal, the caseload is less. There are 3 appeals under Rule of Procedure 220.1, litera A or B. There are the final decisions, followed by decisions about judicial competences and languages, and 47 appeals under Rule of Procedure 220.2, referring to procedure for the unitary patent. The allocation of language of proceeding is therefore most of them are in English with 50%, followed by German with 44%. The work in the panel, the composition of the panels is different. The local divisions, more than 50 cases a year. For example, in Germany, you have 2 German legally qualified judges and 1 of the pool. And for example, in Austria, there are under 50 cases a year. There you have only 1 judge from Austria and 2 from the pool. And the central division, there is it's only a judge from the member states. The technically qualified judges, now we have 61 appointed. Most of them are ordered case by case in 4 fields, in physics, biotechnology, mechanical engineering, chemistry, and pharmaceutics. It's possible to request them from one of the parties or the panel himself. And my first intermediate evaluation is it's an excellent cooperation and a valuable exchange. But I knew this because in Austria we work with the technically qualified judges since the beginning. But there is a decision from the Court of Appeal. They decided that Article 9.1 must be interpreted to mean that if the subject matter of the appeal is exclusively non-technical and there are no technical issues at stake, the Court of Appeal may decide the matter without the technically qualified judges, although Article 9.1 of the agreement is clear and has no possibility of interpretation. That's really a pity because it's not really a good sign for the technically qualified judges that there is the possibility to exclude them. The case in the local division was about a handheld vacuum cleaner. Both parties produced them. The claimant has a valid patent called a handheld cleaning appliance, and he made a test buy with the result that the device fulfills the features 1.3, 1.5.3, and 1.5.4. The interpretation of the claim features was the main issue. The features are called cyclonic separating apparatus arranged in communication with the suction conduit for separating dirt and dust from the airflow, wherein the elongate handle lies transverse to the longitude axis of the suction conduit, and the cyclonic separating apparatus is positioned between the suction conduit and the elongate handle. The reasons for granting the PI was in paragraph 5 of the description is stated that the new US patent shows a Hoover according to preamble of claim 1. And this expresses various indication for the expert to check how the cyclone separator device or the patent compliant vortex flow is to be designed there. The expert interprets the feature cyclone separating device of claim 1 to mean that the separating device is not limited to the tangent airflow. Consequently, the generation of an eddy current which presses the dirt particles against the cylinder wall is sufficient, whereby the comparatively heavier dust particles are separated by the centrifugal force thus generated. The claim in dispute must be interpreted in such a functional related manner that it covers any such vortex flows which enable particles to be separated by means of centrifugal force. Therefore, the features 1.5.3 and 1.5.4 was also fulfilled according to the paragraphs 21 in conjunction with 15. It is generally sufficient for the x-axis to intersect with the y-axis at any point and for a pistol grip to be provided. The fact that the defendant's models are inferior in this respect to the model in figure 2 of the patent in suit, because the handle is arranged significantly further away from the longitude axis from the suction channel, does not produce the realization of feature 1.5.3 according to description. The models of the defendants are also worse in this respect than in figure 2 of the patent in suit to the feature 1.5.4. However, in the view of the skilled person, they nevertheless fulfill this feature because it is not required that the components suction channel, cyclone separator, and handle must lie on one plane axis. Due to the summary nature of the examination of legal validity in proceedings for the adoption of provisional measures, it's not possible to consider a full examination of all legal validity defenses as in nullity proceedings. Rather, the number of arguments raised against the legal validity must generally be reduced to the best 3 from the defendant's point of view. The result was claim 1 proves to be novel and inventive over the prior art contested by the defendant. And the order of provisional measures was necessary due to the damage threatened to the claimant by the infringing product offers of the defendant. The parties are market competitors, infringing designs that are 50 or 60% below the price level of the claimant's models, but contain her patent technology, are undoubtedly capable of influencing consumer purchasing decisions. Thank you for your attention. In my conclusion of 1 year of the UPC, I can say we have made a good start. There is still a very positive spirit of optimism, and everyone is ready to do their best to continue the successful way. I wish you all the best. Have a good quality time in Munich. Maybe I can join you in another year. See you. Bye.